All right. I think that might be everybody that we're going to get here today. Great turnout. We got 12 people here. Thank you for taking time out of your lunch today to come hang out with us, talk about New Mexico record requests. Let's see here. Hopefully, everybody can see and hear me. Okay. It looks like everything is working. I do have my marketing person. Her name is Terry, who I believe is also here too. She'll be monitoring chat for me. Terry, if you could please let in anybody from the waiting room in case it's in the middle of the presentation at all. And if you have any questions, feel free to send them into the chat. Feel free to, raise your hand if you want. Or like I said, I'll save some time at the end for any questions that you have about the presentation or just HOA stuff in general. So I see a lot of familiar names. Hi, Patsy, Sonia, Brandy, Ava. How is everybody doing today? I know it is extra hot over there in Albuquerque. It's hot over here, but it's the surface of the sun because we are in Phoenix. Can't wait till I can actually make my way back to New Mexico so that way I can just escape the heat for a little bit. Oh, see, we already got one in chat. Super hot. Oh, I know. I've been seeing people saying that it's like 104, 103 over in Albuquerque, which is just, oh my God, it's just brutal. Especially because you guys are that high desert too. Like we're down here in the valley and, thank God it's not super humid, but So for those of you that don't know me, my name is Marcus Martinez. I'm an attorney over here at Vial Fotheringham. And I've been with the firm for, looks like we got one more. So I've been with this firm in particular I just finished my 3rd year, so started my 4th year. I've been practicing law here in Arizona for almost the same amount of time. It'll be 4 full years in August. I've been practicing law in New Mexico for about 2.5 years now. And HOA and condo law, that has been the majority of what our practice has been, especially in New Mexico, but especially here in Arizona as well. I'm going to go into a little bit more about what our firm does specifically. But me in general, so I am born and raised in Santa Fe. I went to school at UNM in Albuquerque. So all of my family's in New Mexico. So every chance I get, I'm constantly going back and forth. Before everything happened with COVID, I was probably visiting about once or twice a month, whether it be going to board meetings or whether it be doing court hearings or anything like that. So COVID has kind of put a wrench into that. But once we get back to normal here, I will be making regular visits back to New Mexico. So, if there is ever a time where you need me to go to a board meeting, if there's ever anyone that you want me to meet, even if you just want to sit down and go to lunch, I'm always happy to do that as well. So like I said, born and raised in New Mexico, went to school at UNM. I spent a year teaching at UC Boulder. I was doing calculus, algebra, and trig for college students. Super dry stuff. I realized that I probably didn't want to write papers about the theory of nonlinear equations or, calculus infinitesimals as they reach infinity. So, law school, why not? And I ended up over here in Arizona. And I spent 1 year in Oregon doing like a special program at the University of Oregon. I did the winter there once for 1 year, and I was like, nope, going back to Arizona. So I've been here in Arizona ever since. It's not too bad. The family's a 1 hour flight away, which is awesome. It tends to leave a lot of the little tiny drama stuff over there too. So, it stinks because I don't always have a babysitter. That would be nice. But at the same time, it's like, I'm a peacock. You got to let me fly. So I'm over here in Arizona. So like I said, I'm over here at Vial Fotheringham, and we are your one-stop shop multi-state firm to deal with all of your community needs. Not only do we handle, which a majority of our stuff has been collection related, especially lately with everything going on with COVID, but we also deal with construction defect. We do handle a lot of collections. We handle any type of HOA litigation. So, that's not limited to only matters where the association gets sued, but also matters where the association wants to sue somebody. In some weird instances, there are times where the association may acquire property and they become landlords. So there is landlord-tenant stuff that we also assist with. We handle fair housing claims. We help you with document amendments. We also provide insurance defense, document enforcement, which we've been really successful with that. I've been surprised. Every single enforcement letter that I've drafted in the past 2 years, the matter has resolved itself without having to file a suit. So that has been fantastic. Not that I'm kind of curious as to when I'm actually going to be able to take one of those to court, but if we're going to resolve them on the front end, I'm nothing wrong with that at all. I do also help with some contract review stuff. So if you do ever have an association that's considering hiring a vendor, or if they're looking to get new additions or exclusions to their policies for insurance, I can also help with that. So just kind of an overview of just we are your one-stop shop. I mean, if Walmart is the one-stop brick and mortar and Amazon is the one-stop marketplace online, we are your one-stop legal services place as well. All right. So, as everybody is here today to talk about New Mexico records requests, which can be a little funky since they made changes to the statute a couple of years ago. We're going to go over all of that. And, the goals for today's seminar is I definitely want to touch on what are we talking about when we're talking about association records. We're going to go over those statutes here in New Mexico dealing with the HOA Act as well as the Condo Act. And then I'm also going to give you my top 5 strategies on how I think we should more efficiently deal with record requests in the future in case you ever run into one. So when we're talking about record requests, generally we have this kind of framework as our authority, right? Like we always have to defer to what do our governing documents say about record requests, and our documents themselves are records. So the CC&Rs, which is usually our recorded declaration, I didn't include the plat because the plat doesn't do a whole lot as far as requiring record request stuff, but sometimes you will find that your CC&Rs will lay out some things that it wants to keep on record. Most of the time, that's the recorded stuff anyway. Sometimes it'll maybe some special easement that might also need to be kept on, which is going to be kept either way. Like I said, it's going to be a recorded document. Your bylaws, this is where majority of the time you will find records retention policies if you have any, because this is probably the thing that will govern the association and the board itself. So this is where you will find who is going to hold your governing documents, how long you're going to keep them for, what do they consider documents as far as if there's a special tier that maybe the bylaws goes into. And then the next one would be the articles of incorporation. Definitely not as detailed as the bylaws. Sometimes it may have a reference to something, but your majority of your stuff is going to come from the bylaws itself. And then if you have the power from the CC&Rs and the bylaws to create policies or rules and regulations with regards to your records request, that's another place where you may be able to find your authority on how you are to govern yourself with your records. The other thing, which I consider to be, if there's a hierarchy, statute and CC&Rs, or governing documents, I tend to keep them on an equal level playing field. If one conflicts with the other, then I would always say follow the one that's more strict. So for instance, if you have a statute that tells you that you can only raise assessments by $10, but your governing documents say you can only raise assessments by $5 per year, go with what your governing documents say because it is more strict, and that way you can cover yourself and still be in line with both of them. So, we need to be in line in our record request with whatever our governing documents say, as well as with what the statutes say here in New Mexico. So in case you're wondering, as far as the references for the Condo Act, with regard to the record request, is right here in 47.7C18. And then for the HOA Act, it's 47.16.5. We're going to go into detail on both of those. So the Condominium Act, it's actually pretty straightforward. It's taken from the Uniform Condominium Act, and it's actually a super straightforward in the New Mexico's interpretation of it. So the association shall keep financial records sufficiently detailed to enable the association to comply with Section 61, which is 47.7D9 of the Condominium Act. What that means is this is the section of the Condominium Act that is regarding disclosure to owners when they purchase the property. So the association needs to keep its records up to date so that way when you give a disclosure statement, all of those records are accounted for and the homeowner is getting the most up-to-date information. It goes on to say, all financial and other records shall be made reasonably available for examination by any unit owner and his authorized agents. So you're going to see this language here. It talks about financial records. You're also going to see financial and other records, and then available for examination. These are the key words because they're the same ones that you're going to see in the HOA Act as well. And to me, what that says is whether you're self-managed or whether you have a management company or you are a manager, if a homeowner wants to see your records, you need to be as transparent as possible. You need to make them available. And typically, when I say make them available, it means have them in a certain place and available during regular business hours, which if you're, if you're already a management company, you're already doing that. Of course, we have had some hiccups with that in the past year because of COVID. I mean, clearly we can't just have everything widely open to the public like it has been for the last year. So I have been recommending in the past year, appointment is going to be in line with the statute. That's probably going to change when things start to open up again. But, as far as just the plain reading of the statute, I always interpret it as have them regularly available during business hours somewhere. Oh, looks like we got someone new to come in. Perfect. So the Condominium Act, that one, super simple. It doesn't go into too much detail. It just tells you all financial and other records. In my opinion, it's probably going to be interpreted pretty broadly. Like, unless you have something that is protected by some sort of client privilege or some sort of attorney product confidentiality, you're probably going to have to make it available to the homeowner. At the same time, does that mean that you have to carry records of, the meeting minutes from 1992? Probably not. I mean, so, we can definitely do that within reason, right? Like, I think a 5 to 7 year window is probably the max that I've ever seen somebody actually argue that you should keep records for, or, unless they're the documents that you need to keep forever, like the recorded documents. But if it's more of like your financial stuff, if it is some sort of policy, maybe with a vendor that you had 10 years ago, like those are not going to be as critical as like the recorded declaration, the plat, the bylaws, things like that. So keep in mind that when these statutes are written, the public policy is be as transparent as possible. So it's always easier to err on the side of make it available for examination. Again, seek legal counsel if you have questions about something, whether or not it is protected or whether it is one of these things that you have to disclose no matter what. So that's the Condo Act. Now we get into the HOA Act. So this is where they made some of their changes, right? So all financial and other records, so similar to the Condo Act, of the association shall be made available during regular business hours. So they just flat out tell you regular business hours for examination by a lot owner within 10 business days of a written request. So that is the new little kicker there, right? That we have to address these record requests in case somebody makes a request upon either a board member or the manager, him or herself. Oh, looks like we have a question. What do you think constitutes the record? Oh, Brandy, great question. So on the very next slide, I'm actually going to go into detail as to what specifically is entailed in all of those other records. Okay. So as far as the HOA Act, so they go into a little more detail. They tell you specifically during business hours, for examination, 10 days of a written request. So those are important things to catch on to there. The association shall not charge a fee for making the financial and other records available for review. So we can't charge a homeowner for just letting them come in to look at the records themselves. However, the association may charge a fee of not more than 10 cents per page if they want to take copies with them. This is the only question I've really gotten about this part of the statute is if somebody's requesting digital copies of stuff, are you able to charge that 10 cents per page? Whew, that one is a good old depends, because I guess if you are going with the statute, sure, 10 cents per page for a digital copy. But in my opinion, that's probably taking it a little too far. Digital copies don't cost anything to make, and these records need to be made available to them anyway. Ugh, man, tough. Personally, I think 10 cents per page on a digital PDF, especially if it's like 60 pages, that might be a little, that's pushing it. But under the plain reading of the statute, if they want copies of the documents, you can charge 10 cents per page. So in my opinion, if somebody comes in and they want your whole binder full of records, you can definitely charge them 10 cents per page for having to copy the entire history of whatever the association's records they want. All right, so the next page, and addressing to Brandy's question. So in this section, they outline this in the statute itself. Financial and other records includes the declaration of the association. That's easy. That's recorded. Number 2, the name, address, telephone number of the association's agent. So that would be either the stat agent that is with the New Mexico Secretary of State or the Corporation Commission's office. So that would be whoever that is, or the management company themselves. And that's not too bad. I mean, the name, address, telephone number, it's all publicly available, like I said, on your articles of incorporation. Plus, it's also your stat agent. So, not a huge concern, but I mean, it's publicly available anyway. The bylaws of the association. So 50-50 from what I've seen with my clients in New Mexico, they will record the bylaws or they will not record the bylaws. These are to be provided to the homeowners with that disclosure statement typically. So, again, these are things that are either publicly available or they're made available to the owner already. So easy. The names and addresses of all association members. I had some pushback from one client that they felt like it was an intrusion of privacy to have a list out there of all of the owners in the community. While I understand the concern, the name and address of everyone in the association is publicly available on the New Mexico County assessor page, on any New Mexico County recorder page, or any sort of any clerk page. Like if you just run a basic search of your subdivision, you would be able to see every single homeowner and where they live. I mean, it is what it is. It's public information because we need to know who property owners are. So, make sure that you have a list like this somewhere in your records and make sure that you keep it updated as much as possible, especially when you're dealing with your disclosures. Sometimes this can fall off a little bit, but when that disclosure statement goes out, whether it be for some sort of refinance or a property transfer, that's a great time to revisit just to make sure that you've caught in any of the changes from ownership. So,
Hey, Marcus.
Yeah.
There's a question in the chat. Brandy wanted to know what constitutes quote unquote other records.
Yeah. So great question, Brandy. And thanks, Terry. As far as the other records, this is as far as they go for defining them in the statute itself. And there's 12 different parts. So we're going through each of them one by one. So, all right. So 4 is the name and addresses of all the association members. So 5, this one is probably the hardest to keep up with. Minutes of all meetings of the association lot owners and the board for the previous 5 years, other than executive sessions, and records of all actions taken by a committee in place of the board or on behalf of the association for the past 5 years. So, a couple of things that I like to tell all my clients when it comes to this section in particular. This is a great refresher, a great primer of why your meeting minutes should be meeting minutes and not meeting hours. What I mean by that is when you're in your meeting, do not get crazy into the detail, minutia of every single conversation that happens during the course of the meeting. However, we do want to note anything that is notable. So, if there is something in particular that may have happened during the meeting that we think may be important down the road, these meeting minutes are your life support. They are the sole thing, if the association ever goes under any type of litigation, that is going to make or break your entire case, because depending on how detailed or how inclusive you are with your meeting minutes, that may be the difference between you being successful or paying a lot of money in some sort of a lawsuit. Now, a couple things to note in this. It does mention meeting minutes. So as we know, here in New Mexico, we have open meeting laws. So everything is open to the public unless you close the meeting for one of 5 specific reasons. So that would be like going into the executive for like contemplated litigation. If you wanted to get advice from an attorney, if you're going to talk about the financial or medical well-being of an owner, if you want to talk about a vendor contract, or the financial medical well-being of a vendor's employee. So those exceptional things do not need to be included in those records. However, if you go into executive session and you aren't protected by some sort of privilege or confidence, and you take an action, that does need to be noted somewhere. So, I mean, like I said, this is going to be the place where we go if we ever get sued for something, where we are going to prove that we did or did not do something. So we definitely need to hold on to as much information that we think is necessary, but we don't need it to be a novel of what exactly happened. And Betty Sue said this, Johnny took a sip of water, Maria in the back made a lot of noise during the meeting. I mean, these doesn't have to be meeting hours, they're meeting minutes. And the most important part is that we take a specific note of any actions that are taken and we hold on to these records for at least 5 years. Okay, so that is our first indicator of 5 years. And generally, I mean, the all 1 through 4, they're things you're going to hold on to forever. So that's not going to change. But this is our first indication that we have time limits on the things that we do need to keep a record of. All right, number 6, the operating budget for the current fiscal year. So not too crazy, right? I mean, we have a budget that gets adopted at the annual meeting typically. Sometimes governing documents may tell you to do it at your fiscal year instead of your annual meeting. But the operating budget, we're having to deal with those every single year. It's a great way to kind of indicate the health of the association. Are we meeting all of our financial obligations? Are we not? How are we doing on our reserves? Is there anything weird that is happening that we had to make a payment for? Is that setting us up for a potential special assessment? Is everybody paying their assessments so that way we don't have to think about what happens if we aren't able to meet some of those financial obligations? How are we doing on our legal budget? How are we doing on our insurance premiums? So it's a great way to just make sure that we have that updated and on hand as much as possible. In my opinion, probably falls into the 5-year mark as well. Although if you want to keep budgets for even longer, I'm not going to be upset. So going on, let's see, number 7, some form or some statement, some sort of certification of the current assessments, including regular and special assessments. I have a couple communities that do have a special assessment that is ongoing right now. By definition, special assessments are not forever. They have some sort of a term. So you definitely need to have something on record that shows where that special assessment is coming from, what it's being applied to, and then just something that does state what your current assessments are. And then if you do ever increase your assessments, you do need to provide notice to the entire community. So this is a great way to also keep records of all of the notices that have gone out to people. So that way, when people are questioning whether or not the assessments have been raised or decreased, you have something in your records that shows, no, specifically, it was this board action at this time that increased for this year. Let's see here. Number 8, financial statements and accounts, including bank account statements, transaction registers, association provided service or utility records, and amounts held in reserve. So this one can be difficult depending on how many different accounts you have. If you don't have too many accounts, like I know some associations will have maybe just their operating account, and then they will also have their reserve account. It can be easily, you can get those records very easy because you only have 2 different places that you're going. The transaction registers, the service and utility records, and your amounts in your reserve. Those are probably the 3 most common ways that I see the associations get sued over this particular part, mostly because someone in the association, someone in the community feels that the association is neglecting something, or they feel that they aren't doing enough. So then they target these specific types of record requests to try and figure out where all of the money is going. So these particular records are very important because when somebody starts asking for these ones in particular, you can tell that they're probably fishing for something. So this is always a great time. If you're getting a lot of record requests for these types of things, get your legal counsel involved, and let's start taking a look at all the other things going on in the community to make sure that there's not some glaring hole or some exposure to litigation that we're not seeing. So the most recent financial audit or review, if any, I do have a couple associations that say specifically in their governing documents that an annual audit by a CPA is to be done. I have some that say audit or compilation. This one in the statute itself says the most recent financial audit or review. So clearly you don't always have to do an audit. Audits are very expensive. They're very time consuming. And I mean, a compilation or a review, it's a lot cheaper. It doesn't have the same sort of warranty and sort of like certification that this CPA really backs everything that they're showing in their report. But typically when it comes to a compilation or like a review, I mean, that's what they're doing is they're compiling all of this for you and they're putting it into a nice little packet that you can hold on to, which is one of those records I think you need to hold on to for at least 5 years. I mean, clearly, if you want to hold on to them even longer, one of the great things about association record keeping is that you can sort of govern yourself and make policies on how you want to govern yourself moving forward, which I'll talk about later. So number 10, all current contracts entered into by the association or or the board on behalf of the association. So clearly this would be, your insurance policies. This would be your vendor contract with your management company, any landscaping if you have any pool maintenance if you have any. If you have a particular person that does like the roof or the stucco for the community, this would be any of those contracts that are current. So, if you had one that you did with a contractor 15 years ago, I don't necessarily think you need to hold on to that one unless he's doing ongoing services or he's sort of like the person that you would call if something were to happen. Or let's say that it was a roofing guy and he has a warranty on his work, then you clearly would want to keep on to that. But yeah, as far as the way that I read this, current contracts, something to keep in mind. Any sort of legal representation is exempt from this because that is all protected, and it is all protected by the current attorney-client privilege and confidence. So just something to keep in mind. Here we go, directly addressing the insurance policies. So current insurance policies, including the company names, policy limits, deductibles, additional named insureds, and expiration dates for property, general liability, and association D&O professional liability and fidelity policies. Whole lot of legal stuff there. Pretty much, if you have an insurance policy, make sure that it covers everything that you are supposed to under your CC&Rs. And if it does cover any and all of these particular things, make sure that you have a record of it. It is free for somebody to request and to examine. I had one association recently where somebody had their property damaged. It wasn't their real property, it was their personal property. And they were trying to say that it was due to the association's neglect to maintain that their property was damaged. So therefore, the association needs to put it onto their insurance. I had to express in my letter very, very sternly that while we do acknowledge that we have insurance, here is our policy. It is not an umbrella catch-all for any sort of damage that happens within the community. Clearly, if the association was at fault for something or directly did something, that would be a different story. But if some unknown third party causes damage to your personal property, I mean, I feel terrible for the situation. However, I will not, and the association policy will not tender or entertain any sort of claim for that. So, I'm sorry. And then number 12, this one, any electronic record of action taken by the board. This is kind of a repeat from the previous slide about the meeting minutes, but I think this one probably entails to the Nonprofit Corporation Act, which allows for associations to take an action outside of a meeting as long as there is unanimous consent and it is in writing. So if you have some sort of an emergency situation, or if you have like what has been happening a lot with COVID, where people aren't able to meet together quick enough, boards can take action outside of the meeting as long as there's unanimous consent and it's in writing. I think this one is trying to address that those records need to also be kept, even if they're not meeting minutes per se. So, keep in mind as well that an electronic record of action could also mean that if everything is being done by email, those emails can be considered association records. One of the things I always recommend to all of my board members is make a separate email that you're going to do all of your HOA stuff with, because the last thing that I like to do in the middle of litigation is file motions to exclude evidence because you use your personal email and maybe you and your significant other have been exchanging photos, videos, or other correspondence that maybe we don't want other people to see. Unfortunately, if you are using your personal email, those can be discoverable. Clearly, the other side would have to prove that it's actually relevant to the case, which is why I would move to exclude it. But keep in mind that that also means that I am going to look at it, as well as probably a paralegal, as well as the other side's legal counsel, probably that homeowner, and then probably that paralegal. So, no personal emails. Trust me, it's a lot easier that way. And it helps to maintain everything too if you don't have a million different things going. Julie, great question. Are Zoom recordings considered records? Oh, I personally, in my opinion, I think so. So in New Mexico, it is a one-party consent state when it comes to recording. So if I am currently on a phone call, or if I'm on a Zoom call, and I choose to record it, I consent to the recording, I can record that phone call or that video. As opposed to California, for instance, which is a two-party consent state, you cannot record unless both parties consent to the recording. So in my opinion, I think if you are recording your Zoom meetings, I think those are probably some electronic record. That is probably considered a record, in my opinion. Yeah. And at the end of the day, like, I mean, you're in open meeting anyway, and everybody that's there was already present for it. So, it's not like something is going to be hidden in there that like was not going to come out either way. Clearly, portions of Zoom recordings that maybe it's an executive and maybe there's any of those 5 reasons where you could close the open meeting, that would not be considered one of those records. But yeah, great question. I think that, yeah, probably, especially with the way that things are trending, where teleconference and Zoom calls are becoming more of the norm, you're probably going to see a lot of more traction of where people are going to say that these are definitely considered records just like any other ones. So this is the real trap that was set up by the statute. So under Section D, and these were additions in the last 2 years by the legislature, the failure of an association to provide access to the financial and other records within 10 business days after receipt of a request creates a rebuttable presumption that the association willfully failed to comply with the HOA Act. A lot owner that's denied access to financial and other records is entitled to the greater of actual damages incurred for the association's failure to comply with the subsection, or $50 per day starting on the 11th business day after the receipt of the written request. So a couple things to keep in mind here. All right, so first, it jumps from business days to calendar days, which is a little strange. So that's always something to keep in mind. When the association record request can be received by any member of the board or the manager, him or herself. So that being said, it's extremely important that if you as a board member or you as a manager are ever given some sort of record request, and typically they're done through email, I don't see too many that are actually handwritten or in a letter form anymore, unless it's coming from an attorney. But when that email comes in, your clock starts ticking to make sure that you have the record request going. So there has been some debate going on as to, like, with everything going on with COVID, if a homeowner makes a record request and there's nobody currently physically at the office and we're only by appointment hours only, does that comply with the statute? The answer is I don't know, because nobody's actually fought me on that. And, COVID seems to be dwindling right now. So I don't think anyone's going to actually take it to court and it's going to be some sort of case law. But in my opinion, providing access to the records, I think if somebody reaches out to you and they want to look at certain records and you respond to them within 10 days and you're setting up a time for them to meet, I think you're probably following the statute, especially because it's not like you're just trying to keep them away from it. We're dealing with, state of emergency health stuff right now. At the same time, when everything goes way back to normal, as a management company, you're going to have all of these records on hand. If a homeowner shows up to the management company and asks to see some records, clearly we could just very easily make them available to them. And if they want to request copies, we could charge up to 10 cents per page. If they do it electronically through email and they want us to provide PDF copies, I think that would be okay as well. But we need to make sure that we're addressing this 10 business day issue. So you get 2 weeks from when you get a request to make sure that you comply with that. Otherwise, potentially there's $50 per day starting on the 11th business day for failing to comply with that request. So in the 2 years that I've been dealing with these, I've had 3 different homeowners come to me and try to claim money damages under this. One of them was in a condominium, and I quickly told him, like, you're in a condominium, this doesn't apply to you, and that got him to back off. I had another one that claimed that we were not, and then we just gave him all of the records, and then he was fine. The third one tried to claim that we failed to provide documents because we were in the middle of litigation, but we weren't able to contact that homeowner directly. We could only contact their attorney. So it was very unique circumstances. I did a search of case law this morning. There still is no case that actually has addressed this type of situation. In my opinion, if somebody were to bring a claim for this, they could probably get whatever damages of the $50 per day. And then also they can probably get their attorney's fees under the written language of the HOA and Condo Act and the governing documents themselves. So this could be a very huge penalty. I haven't seen it levied on any of my associations, and I haven't seen an association that had to deal with this so far. That's not to say that I want to be the guinea pig case either. So if you are a board member or you are a manager, make sure that you are addressing these record requests when they come in. We're doing pretty good on time. It's only 11:40. Perfect. So one of the things that I think a lot of people overlook is this is not specifically in the record request portion of the statute. However, this is a hidden record that I hope everybody is keeping up with. This was also a weird addition with the statute change 2 years ago. So under 47-16-7 of the HOA Act, within 90 days after being elected or appointed to the board, each board member shall certify in writing to the secretary of the association that the member has read the documents, will work to uphold the documents and policies to the best of their ability, and will willfully discharge the member's duties to the association. So usually that was their fancy way of saying they will do it free of conflict of interest, and they will treat everybody fairly and reasonably in the community. The association shall retain each board member's written certification for inspection for 5 years after the board member's election or appointment. So this is one where it's not specifically in the record disclosure part of the statute. However, you do still need to address this, especially if your board has not done one of these certifications since the statute took place, or if you just recently had some elections, you have some new board members, make sure that they're keeping up with this portion of the statute. At the same time, the statute even goes on for this to state that if a homeowner is a director and does not do this certification, it doesn't nullify any of the actions that they've done. The association does have the ability to suspend that board member for not doing the certification. But like I said, at the same time, the statute itself says that any actions taken that are in compliance with the Act or the Nonprofit Corporation Act, they're not going to be nullified or voided out by not fulfilling this. But, let's just make sure that we're actually complying with this portion. Not too hard. I mean, and on top of that, it also gives us a reason to tell all of the board members, like, hey, do you actually have all of the governing documents? Have you read through them? Have you seen some of the things that you are subject to and the duties that you hold? If you ever need, I also offer board trainings for all of our clients. So if you have a brand new board and you think that they just need a little bit of help about their fiduciary duties, if you need me to explain to them what the governing documents say and some of their obligations, if you need me to go in and let them know about some of the things that their bylaws say, or what types of actions need to be taken when you're in a regular board meeting just to make it more efficient, or how it just functions as a whole, I'm here. The way that I see it is, if I educate you managers and you board members, then you only need me when the serious stuff happens. And that's great, because I'm expensive and I understand that. So I always think education is the key, especially if you have brand new board members that have never been on a board before, or if you feel that maybe it's just time for a refresher and maybe they need to hear it from me instead of from you managers, just let me know. I'm always happy to provide that for you. So let's wrap everything up here. As you can see from this little image that I have, I mean, this is sort of the most basic version of what records do in general, right? Like, they try to be as transparent as possible with all of the community. I mean, at the end of the day, all of these associations are nonprofit corporations that are subject to shareholders. Your shareholders happen to be community members. So those community members, they are able to see all of the things that you're doing. And a lot of the times we want that, because we want homeowners to be informed in their community on what is going on. We want them to be aware of who is voting for what when it comes to actions in the community, so they can either hold them accountable when it comes to re-election, or they can keep re-electing them because they like the things that they're doing. So, you have these records that get created, and then we have some form of distribution. We have some form of active storing. We have some form of inactive storage or retention. There's disposition, in case we ever do we need to keep them, or do we need to get rid of them? If we keep them, then we need to figure out where we're going to archive and how we're going to archive. And then we're all back at the creation again. So, you know, it's just this life cycle ongoing over and over and over again of all of these records. My 5 best tips, 5 best strategies for dealing with record requests is: 1, keep all of the records in one place for examination. I cannot tell you how many times I've had brand new community managers that didn't realize that this is actually something that they have to do on a normal basis. So in my experience, um, I've always had associations that will just have a binder. Let's see, I will cover up the name, but it will just have literally everything that you need here. So you got your plat map, your declaration, your bylaws, your articles, any policies, any regulations. Sorry, it's a little fuzzy there. But if you have some sort of folder like this that just has all of your records, that's half the battle for you, because you've already collected everything. Now, the other half is just making sure that you regularly upkeep it. So if you keep them up to date and then you already have everything kind of sorted, when an owner comes in asking for something, it's very easy just to flip to that section that they're looking for. And then if they want copies, you can make copies. So in my experience, that's been the easiest way to keep them all in one place. So you're not having to go to 5 different places. Clearly, if you have bank account stuff and you have other financial stuff, you have to go to them first. But you know, if you're getting all of those documents in preparation of your meeting anyway, and then you just archive them or keep them in the same place, that is going to it's going to relieve you of 99% of these record requests very easily. Make sure that you update any contracts, contact information, insurance policies, and financial records on a regular basis. So again, this kind of goes back to number 1. Number 3, address the request as soon as possible. This goes towards the statute with the 10 business day portion. Also, you know, just the quicker the better. I mean, the sooner we can knock it out, the easiest. Like I said, if you do end up seeing a lot of those utilities or bank account or financial type of requests, definitely let your legal counsel know, because the owner is probably fishing for something. Just quick heads up, penny for my thoughts there. So the other thing that I have been doing a lot of recently with regard to these is what I call a records retention or records request policy. So clearly, if your documents allow you to be able to govern yourself on how you are to retain records and how you're going to dispose of them, you can create a policy that helps to streamline all of this and keep it in one place. So if you have a policy that says how long you're going to hold on to those records, clearly we have some requirements from the statute about the 5-year mark, but that's a great indicator, 5 years. Also, we can say where they are to be held, usually with the managing agent. We can also have a policy that will direct some of those record requests to only the managing agent or only the secretary for the association. And that helps to limit the amount of exposure, because we're not having 8 different record requests going to 5 different people. If we streamline it to only 1 or 2, then at least it'll be easier to address every single one. And then if we completely miss the ball on one, it's like, well, were you aware that we have a policy that actually says you are supposed to make your record requests to here or go to here to be able to deal with them? So that's one of the things that a lot of people have asked me for. If you're interested in that, definitely let me know. I've been doing them on an hourly basis, but I think typically they've been coming out to about $250 to $260, depending on how many revisions we've been making to them. And then finally, like I said, consult with legal counsel to determine if a record should be available for examination. So if you do have any weird type of things that do come up, I've had a couple of times where, let's say somebody was hurt and they want to ask for certain things from the association. If it concerns their medical or financial or well-being, those are ones where you definitely want to come to me first to make sure they're even okay to distribute at all, or if they're even anything that you should be holding on to at all. For instance, like if you close your executive for the purpose of talking about someone's financial or medical well-being, you definitely don't want to include that in any of your meeting minutes. And if it is included in any of your meeting minutes, we definitely want to make sure that we're able to redact any of that information before we make it official into our record or before we disclose it to other people. So that is all that I have for this presentation. If you have any questions, you can always email me. I'm also definitely available here to answer any questions that you have. Oh, looks like we got a question from Brandy. Is it acceptable to direct an owner to the community website if records, financials, contracts, meetings, etc., minutes, etc., are kept there? Great question. Yes, in my opinion, I think that's fine. I mean, the whole basis of the statute is, do we make these records available? And I think when we put them up on a website for everybody to see, that, in my opinion, is making it available. The only downfall or the only pitfall I would see from that is you end up with 80-something-year-old person that has absolutely no access to the internet, and then they are unable or unwilling to conform and get on the website to be able to get everything. You will still probably have to make everything available by paper under the statute, if that makes sense. Because yeah, I have, believe it or not, I've had a lot of instances, you know, and it's pretty typical. I mean, most people that have most of the money are typically older. So if you end up with some retired persons that either are living out of the state in a couple different places, or if they just literally don't do well with technology. We've had instances with Zoom meetings where people have just been unable to log in to Zoom, and it's like, well, we could also make it available by phone for you, you know, so it could be easier that way. I haven't had anybody say that they're reluctant to have a phone number, but I have had people say that they are reluctant to email and they are reluctant to logging onto a website in order to see stuff. So, but that's great. If you have a website where you're keeping all of these documents, even easier. Wow. I mean, it sounds like it might be a little tedious as far as constantly having to scan and upload stuff. But I mean, hey, if everything is going digital now anyway, clearly I'm going to encourage that. So, see, any other questions from anyone else? I know we covered a lot of information. It's not the end of the world, right? If somebody makes a record request, clearly they're entitled to do it. I mean, in theory, every single homeowner could ask for every single document that the association has at any time. So when you kind of frame it that way and you realize that there's really not that many record requests, and you know, most of the time, as you probably can tell, when people aren't necessarily super concerned or showing up to meetings very angry, they're pretty happy with what you're doing, or at least they trust that you're doing the right things for them, which is a good thing. So if you ever have any questions, you know, like I said, feel free to shoot me an email. If you have any associations that you think might benefit from this, I'm sure Terry is going to post this recording on our website.
Yes, I will.
Perfect.
It will be on our YouTube channel.
Oh, it'll be on our YouTube channel. Perfect.
I'll post in the chat. I'll post the here.
That's great. And like I said, I mean, right now, clearly, New Mexico is still a little shut down, just compared to Arizona. But the second that I can, I'm going to make my way to New Mexico. I know Quentin and I are going to be partnering up with management companies to do presentations similar to this one. Terry, I think we have another presentation in August, right? What was the topic of that one again?
August is going to be Zoom meeting, virtual meeting 101 etiquette.
Oh, perfect. Perfect. Yeah. So make sure you tune into that one just for the sheer laugh factor, because I'm going to show a lot of examples of things that have been done in board meetings in the past year that you definitely don't want to do. So if you do want to attend that, I will also give a bunch of tips on handling those types of Zoom call meetings. Look at that. We went to 11:52. So I didn't take, or 12:52 New Mexico time. I didn't take up your entire lunch. But if anybody has anything else that they want to cover, feel free to shoot it into the chat. Send me an email, give me a call. Let's see, I'll put my phone number into the chat as well. There you go. But it looks like everybody is completely satisfied with their 100% free class today. Thank you, Sonia, for making me part of your day. I appreciate it. And yeah, so, all right, if there's anything else, please let me know. If there's anything that I can help you with or any of the services that I mentioned before, just let me know. Oh, absolutely no problem, Brandy. I'm glad that you were able to make it today. All right, then. Well, and also, if you have any questions for Terry, Terry, can you put your email in there? She handles a lot of our marketing stuff, or if anybody wants to partner up with us, Terry's also a really great resource for that. Oh, hey, Ava. Awesome. Thank you for joining us today. I appreciate it. Perfect. All right. I know it was kind of last minute that I sent an email over to Nigel, and then he sent it out, which I really appreciate. And for everybody that joined us, thanks again. And yeah, definitely look out for some email blasts from us. And be on lookout for our August CLE, and we'll just get back together and we'll talk about some of that Zoom meeting stuff. I think what was the other one that we had planned for? I think it was for October, right, Terry?
Yes, we have October. We'll be going over New Mexico case law.
Perfect. Oh, yes, that's right. So what I'm going to do with that October class is I'm actually just going to give some of the more landmark cases or the current state of the law when it comes to enforcement. I don't think I found any record requests, but I'll include record requests if I do see any. I'll definitely talk about just like covenants in general, and then let you know about any cases where I find any sort of wrongdoings by any boards, so that way we could learn on what not to do in the future. But all right, thanks again, everybody, for showing up. I appreciate it. Again, my name's Marcus. If you need me for anything, just let me know. Otherwise, I hope everyone has a great rest of their day.